I want to introduce our next panel, which is called Legal and Policy Frameworks for Understanding the Impacts of Racialized Digital Technologies. And with us for this panel, we have Jessica Eaglin, Associate Professor of Law at Indiana University, Margaret Hugh, Associate Professor of Law at Washington and Lee, and Ann Washington, Assistant Professor of Data Policy at New York University. And joining us to moderate the panel, Tara Ramchandani, who is a partner litigator at the Relman, Dane, and Colfax firm here in Washington, D.C. So please give me a hand in joining this next panel. Thank you.
Hey, good morning, everyone. So I just wanted to give a quick introduction to our panelists so you know who you're talking with. And each of our panelists has a presentation to give on their work, and then we'll open it up to questions. I'll throw out a few questions, and we can hopefully have a little bit of a dialogue. So it's great to be here this morning. Thanks for having us. Thanks, Charlton. Okay, so sitting right here is Jessica Eaglin. She, as Professor McElwain said, she's an associate professor of law at Indiana University. She writes about sentencing reforms adopted in response to the economic pressures of mass incarceration to illuminate how they will impact underlying socio-political transformations that sustain the socio-historical phenomena. Her recent work focuses on the proliferation of technical reforms, in particular actuarial risk assessment tools and the obscured perils they present for punishment and society. Jessica Eaglin has 2 publications forthcoming this year, so you should all check them out. The first will be out in 2019 in the Washington University Law Review, and the second will be in 2020 in the Cornell Law Review. She also recently won the university-wide Outstanding Junior Faculty Award at Indiana University, Bloomington, for her ongoing research and scholarship, and was selected for the Trustees Teaching Award by the law school. So we're thrilled to have you here. Margaret Hu down there is an associate professor of law at Washington and Lee University School of Law, and her research interests include the intersection of immigration policy, national security, cyber surveillance, and civil rights. Previously, she served as a senior policy advisor for the White House Initiative on Asian Americans and Pacific Islanders, and also served as special policy counsel in the Office of Special Counsel for Immigration-Related Unfair Employment Practices in the Civil Rights Division of the U.S. Department of Justice here in D.C. As special policy counsel, who managed a team of attorneys and investigators in the enforcement of the anti-discrimination provisions of the Immigration and Nationality Act, and was responsible for federal immigration policy review and coordination for the Office of Special Counsel at DOJ. So we're thrilled to have her here with us. And then Ann Washington is an associate professor of data policy at NYU. And her data-intensive projects on public sector technology draw on both interpretive research methods and computational text analysis. She holds an undergraduate degree in computer science from Brown University, which I don't think we connected yet, but I just attended my college reunion this past weekend, and a graduate degree from Rutgers University and a doctorate from GW School of Business. Professor Washington serves on the advisory boards of the Electronic Privacy Information Center and the Open Government Foundation. The National Science Foundation has funded her research multiple times, including a prestigious 5-year NSF career grant on open government data. So I think we're going to have a really interesting conversation this morning. I don't think an hour and 15 minutes is going to be enough, but hopefully we'll get a look at what all of these wonderful women are doing. So thank you.
So I guess I will begin. All right, so I just want to first say it is a pleasure to be here, and the first panel of the day was fantastic, and I'm looking forward to continuing that conversation. Secondly, that prior to joining the faculty at Indiana University, I actually was counsel at the Brennan Center for Justice at NYU, so it is a pleasure to be back in this NYU DC space, and thank you so much for creating this space for us to have this conversation. My comments today are going to be relatively brief. I just want to talk a little bit about the introduction of technology into the criminal justice space as a solution or a partial solution to the pressures that mass incarceration, the economic pressures that mass incarceration has placed on the states in particular, and the tensions that the drive for technical reforms is introducing into this space. So I came to the space of sort of technology, race and technology, from a genuine interest in the responses that states were adopting and the reforms that they were adopting in response to the economic pressures of mass incarceration. And of course, at this point today, mass incarceration is, a term that people have great familiarity with. But prior to about 2008, that was not the case. The exponential increase in the prison population in the United States was an issue that scholars had been writing about, criminal justice scholars, race scholars, had been writing about for decades, but did not really get traction in terms of massive reforms across the states until there was this additional economic pressures that came with the economic recession, the Great Recession of 2008 or so. And so one of the many reforms that has been proliferating since that time has been the introduction of actuarial risk assessment tools into the criminal justice decision-making process. Actuarial risk assessment tools predict the likelihood of a defendant engaging in criminal behavior, again in the future, on the basis of statistical analyses of data that has been collected about offenders who have been observed in the past. And it relies on ostensibly objective factors to make a standardized prediction of this likelihood that somebody will engage in criminal behavior in the future, in the hopes that this additional information will allow criminal justice decision makers, in particular judges, to make better decisions about who to release and potentially to reduce reliance on incarceration by making sort of smarter decisions about who should be incarcerated. And on its face, it sounds like a great solution, a great intervention, but there are a number of problems in the actuarial risk assessment tools being introduced at various stages of the criminal justice process, including pretrial detention, where it is perhaps most popular, but also in the context that I focus on specifically, which is post-conviction sentencing. But it's also expanding into other contexts. So the police use of predictive analytics is very much correlated with discussions about actuarial risk assessment tools more generally. And you see this even now. There's discussions of prosecutors getting access to actuarial risk tools that are going to make these predictions about people's future behavior as a way to make the administration of criminal justice more efficient and effective. But the concern is, or there are many concerns, but there are sort of a number of concerns that focus on how we make these tools and what these tools are actually going to do. And so on the one hand, the tools rely on factors that, while they are objective or they appear objective, they are reflective of a society that has transformed to sustain this socio-historical phenomenon of mass incarceration, which refers not only to the extensive reliance on incarceration, but also its disproportionate impact and its on marginalized communities, particularly African American men and women from urban centers. And so to the extent that these risk assessment tools are predicting the likelihood of future behavior, they're also reflecting police practices. They're reflecting socioeconomic status. They're reflecting, and they explicitly rely on gender. So if you are a man, you are that much more likely to engage in criminal behavior in the future, so says the tools. And so a number of questions have arisen in the public policy space, right? Should we use these tools as a way to help us move away from our reliance on incarceration. But in the legal context, there is another debate that is going on, which is how do we manage the construction of these tools? Do these tools comport with our notions of equality and our constitutional guarantee of equal protection? And what has fascinated me in this context is that there is a presumption that the Equal Protection Clause and that the constitutional protections, which create a very low floor, are going to be enough to manage the problems or the questions, the policy implications and the political implications of actuarial risk assessment tools. And this debate about specifically risk assessment tools is critical when talking about sort of the introduction of technologies in criminal justice more broadly, because these tools are sort of considered ground zero on this particular topic. And so I'm going to briefly talk about some of the ways that we think about equality sort of managing this issue, and then I'll say just a few words about why I think all of this is not good enough before turning it over, I guess, to my colleagues here. So what's interesting in the context of equal protection and the construction of risk assessment tools is that the risk assessment tools aren't new. We've been using some sort of predictive measurements in criminal justice since the 1920s. And now, as we are moving in this direction towards big data, predictive analytics, these risk assessment tools are considered new because there's more data that they're relying on, and the algorithms can be stronger than they once were. They can rely on more factors than they did in the past, not just sort of criminal history, but personal characteristics, things like your employment background and your education background, what neighborhood you're from. These kinds of factors are now being incorporated into the tools in ways that they were not before. There is actually a hot debate about whether race should be included as a factor as well, or controlled for in the tools as a means to ensure equality in what could be considered equality based on the outcomes. So to make sure that that individuals are just from different racial backgrounds or gender backgrounds are just as likely to be categorized as high risk or medium risk or low risk, in hopes that then judges will make their determinations more uniformly. And so one argument is that equality in this context actually means equal outcomes. Another argument is that equality means considering all the same factors. So if what is going to be considered for risk, for an assessment of risk for me is my gender and my education and my criminal history, then that should be the same factors that are used for anybody else. What's interesting here is that these debates, this kind of question about what is equality in this context, also is not new, right? Because there's a concern that the way to control for these technologies it changes over time. And we've introduced technologies. Technology itself is not new, we all know that. But in the context of sentencing that I focus on, we've used sentencing guidelines that were basically technical, numerical rubrics to categorize and classify defendants for certain terms of punishment since the 1970s, 1980s, which is exactly the time that the prison population started to rise. And so one of the questions is, what does equality mean, and how is that different or distinct from uniformity and standardization, which is sort of our sort of gut reaction, a space that makes us feel comfortable when responding to socio-political pressures. And in this context, the sort of drive for risk assessment tools, people will say that this is a reform to address many problems in the criminal justice system. We're concerned about bias. We're concerned about our reliance on incarceration, unnecessary incarceration, and that these concerns are going to be addressed by diverting or potentially identifying individuals who may be diverted safely into the community or alternatively, who need more supervision. Often that supervision comes through other new surveillance technologies like GPS monitoring, electronic ankle monitors, and things of that nature. And the concern is that we're so busy thinking about how to conceptualize what equality means in the construction of the tools and the implementation of the tools that we're actually missing the bigger picture, which is why did the carceral state expand? What does it mean to intervene to reduce not just the reliance on incarceration, but the political transformations that sustained our excessive reliance, or potentially excessive reliance on incarceration and the carceral state in our changing society. And what's interesting in the context of technology is that it gives us an out to avoid those hard questions. But in avoiding those hard questions, we are potentially creating the framework to sustain our reliance on the carceral state. And so most of what I think about in the context of risk assessment tools is sort of how does technology bump up against a phenomenon that has disproportionately impacted minority communities. And it's not enough to debate the legal context or legal concept of equality and the construction of the tools without engaging with why are we using these tools as a response to the changes that have led to this disproportionate impact.
Before we move on, let me just ask you two quick questions. Okay. So I'm curious just to get your thoughts on, you talked about sentencing guidelines, right? And we have these frameworks that we know, despite being numerical, led to incredible disparities in sentencing. Just take, crack versus powder cocaine. What are you seeing in terms of similar disparities resulting from a framework that is ostensibly neutral, but may have a consequence that takes us, much farther away from equality than we intended? So that's question one. And then the second is just when you talked about monitoring people after, right? Using these tools, say who needs more monitoring, and then in fact you continuing to use technology to do that monitoring. And when we gather data on people, right, what are we learning about their actions that people who are not being monitored might also be engaged in, but you just don't know? And so then are we seeing sort of cumulative effects of negative effects from monitoring because you're able to gather information about somebody that you're not gathering about somebody else who didn't end up with the monitoring?
Thank you for those questions. So, I love that. I love the questions because both of them are really driving at what is the impact of these technologies in communities, like on the ground. And what's interesting, at least in the legal scholarship field, is that there's not a lot of study about that yet. And that's starting to come out, and it's coming it's coming from sort of the sociological literature, but there's a resistance to measuring the effects of the technologies as much as there's an interest in measuring the accuracy, the technical accuracy of the technology. And so one of sort of the interventions that I am sort of constantly urging when I talk about sort of the history of the sentencing guidelines, which were rolled out in the 1980s, and the crack versus powder cocaine sentencing disparities is the perfect example of how these guidelines didn't necessarily fix everything, and they created their own problems, but we became more resigned to, like, this is just the way sort of life is. Just to say that in the 1980s, when we rolled out the guidelines, there were tons of studies about the effects of the guidelines on the ground. And now when we're rolling out risk assessment tools, we're actually seeing most of the literature is focusing on how, on the technical development of the tools. And so there's this missing body of literature about what are the actual effects, and there are big debates on it. There's reason to think that it's going to disproportionately impact minorities. There's reason to think that, maybe the way that people use the tools will not, but we don't actually know the answer to that. And there are a couple of scholars who are starting to write about that. And so, so moving beyond just sort of the conceptualization of what equality might mean and moving to how does this actually impact us as people is a critical question that needs to be, a critical gap that needs to be filled. And then the second question goes to sort of the expansion of the monitoring, the monitoring technologies, and what is the effect on that, not only for the defendants who have, for whatever reason, been drawn into the criminal justice system, but also on their families and their communities. And I think that that's another area where there is a sort of a lack of awareness. I think the perfect example, of course, is electronic monitoring, where the individual is now going to be, ostensibly, they aren't serving time in jails or prisons, which is not necessarily true, because oftentimes electronic monitoring is in addition to the time that you spent, or you might spend less time in jail, but you are still spending time in jail, and then you come home, and now that electronic monitoring is leading to sort of surveillance, not only of you, but also of your family. And the problem here is, again, I think there's not enough study of the effects in and of themselves, because it's always a question of better than what. So people who would say, well, it's got to be better than, this has to be better than jails, it has to be better than prisons, and it very well might be. Maybe it is, right? I mean, there's a lot of reasons to think that it is better, but the amount of time that people are spending under surveillance, the intensity of that surveillance, and the fact that I guess that once you are in the criminal justice system, once you start being monitored, you're that much more likely to stay in the criminal justice system, is a kind of framework that is lost in the sort of drive for a technical solution. The idea that the technology has to be doing something good is a precept to our analysis of what the technology is actually doing. And so much of the challenge, particularly when we're talking about marginalized populations and the introductions of technology into criminal justice, is saying, let us measure these interventions for what they are and not for what we hope that they could be. And there is a gap in that sort of conceptualization.
So as a public sector technologist, my research is concerned with the social implications of innovation, particularly in governments. So I was trained as a computer scientist and an organizational scholar. So my research tends to consider how governments are implementing emerging technology and what are the social impacts of that. So why is a computer scientist with a panel of lawyers? All right, so my research, my most recent paper posed a question that Danielle Keats-Citron started to answer in 2008 with her piece on technology due process. So the piece is called How to Argue with an Algorithm, and I was looking at the impact of the Wisconsin versus Loomis case, where it's State versus Loomis, and the Wisconsin Supreme Court upheld risk assessment scores in sentencing. Now, the court based its reasoning on this idea that the defendant had due process because they had this ability to argue against the risk assessment score. And my question there was the court right in saying that the defendant could argue with an algorithm? And sadly, the reasoning the court used, according to all of the data science literature, actually is no. They really did not use a reasoning that any technologist would think is pertinent. And this is important, and the reason I also wanted to have this piece appear in a law review is so lawyers can start to understand how technologists think about technology, and where's this gap between what the law is doing right now and what's going on in the literature and data science. So where this all started is that ProPublica, in 2016, the investigative journalists published a piece saying that the North Point risk assessment score, called COMPAS, they were operating as North Point at the time, was racially biased. And they went through a long group of statistical claims about this. Now, the statistical claims are refuted in lots of different ways. But basically, they were saying that, North Point refuted all the statistical claims, is what I should say to that point. What was most important was that ProPublica released their information that they got through public records laws. There was in Florida, so there's a lot of open data there. They released it as an open data set. And it started off, I think, what is the most and first scholarly debate on data science. there were over 250 academic articles published within a year. And give statisticians and computer scientists raw data, and it started a statistical bar brawl that you would never see and perhaps will never be seen again. And data scientists are not exactly the ball brawl kind of people, but everyone joined in. There were journalists and computer scientists and machine learning specialists. And what I did was I looked at this body of research to understand what types of arguments were being made by data scientists and what kind of arguments were being made in the court, and started to look at what these differences were. And I do think what's spectacular about this argument is it could happen at all. Most data science happens behind closed doors. It's proprietary material, proprietary data. Nobody gets to see the algorithms, and nobody gets to understand the outcomes. So what is usually the mark of good science, which is that everybody is able to participate and falsify claims, often does not happen in data science. And I really just want to put that into the conversation today, that is one of the reasons why we are having these conversations, is that there's not a lot of outside verification of what's happening. And therefore, you're more reliant on data being simply interpreted. And let me try to explain a kind of complex statistical idea in a pretty simple way. I'm saying the defendant did not have the ability to go against this very high risk assessment score. The defense could do a couple of things that the court did claim. The defense could say that they could answer questions correctly, and they could verify that the final data set that was used in the evaluation was correct. Those two things are absolutely true, and that's a start. It's a necessary but not sufficient step to have the right data. But what is really important here is how the algorithm processes that data and what types of things are important to the algorithm that the defense could never know. And this gets into a conversation about what's a statistical base rate. But imagine this. So we all play many different roles in our lives, and I think you can imagine all the ways that you are to all these different groups. Just for my job as a professor, I'm a researcher, I'm a mentor, I'm a scholar, I'm a computer programmer, and I'm an employee. So if someone were using an algorithm to decide something about me, I would have to know which one of those roles was the most dominant thing that was going into that algorithmic score to determine how I fit in to the statistical groups. So let's say I'm evaluated as a female teacher. There are lots of people who teach who are female, and so therefore my base rate and that population that I would be compared to would have a lot of people in it. If I'm compared to or seen as a female computer programmer, that's kind of a smaller group. So the statistical base rate and how I fit into that group would be different. So Mr. Loomis, who was arrested in Wisconsin, is being evaluated by an algorithm that determines that he's highly violent. And in that determination, they are looking at a base rate of other people who have been arrested in the state of Wisconsin. And this is a shout out to one of my students in the EDD program at NYU who let me know this one particular fact, that the area of Wisconsin where Mr. Loomis is from is the most highly incarcerated zip code in the United States. So automatically, he is being compared to a group of people that will automatically push him into one category. And that there's a report from the University of Wisconsin-Madison in 2013 that looked at census data and came up with that determination. So what we're trying to do with these algorithms, I just want to bring us back to that there is a valid intent in some of these things, is that they're trying to understand how to calculate and determine public safety. What we are actually asking is not a question about, are we going to have public safety? Who is most likely to commit a crime? We are really asking a question about who is most likely to be arrested, and also we're asking questions about where people come from. This is very much to Professor Eaglin's point about the historical part of the data. So we're asking questions that are based on the data that are available versus what are the questions that we're trying to answer. And this is one reason why we keep repeating issues that are coming up that are structurally imbalanced. And if we ask that question, the hypothetical I like to use for this is, Mr. Elliott of Elite Town more likely to be arrested than Mr. Smith, who's in the sad section of town. And of course, sad section of town is overly policed, and that there are a lot of arrests, and perhaps there's a higher incarceration rate. So if we're comparing these people to the base rates of their communities, obviously there's going to be a difference. What ProPublica found in their data was that a teenager who lived in a zip code that had high arrest rates had a higher risk score, but had never committed a crime before. There was an older man who had an extensive criminal record, albeit in another state, who had a much lower risk score. Now, so risk scores, by definition, are not individual assessments. If I'm thinking about my personal safety and also the public safety of any community, why use neighborhood characteristics? I think if somebody has a perfectly good criminal record, we should be using it, and not just basing it on where they're from or these other rates. So when I think about this, I'm thinking, why are we phrasing our questions such that is it Mr. Elliott of Elite Town, who has no relatives in jail, more likely to commit a crime than Mr. Smith, who has a sister, in Sing Sing or something, right? Like, why are we framing it in these ways that are based on family characteristics? Why are we basing questions based on neighborhood characteristics? And I think when we start to pull out from that perspective, then we can start asking questions that we really want to ask and get to the points that we're really trying to get to without thinking about the implications of how this impacts other people. So in the end, I'm thinking through that when we're talking about alternative claims that could be made in Loomis or for other court cases that involve technology due process, I think that we cannot rely on data quality alone. We have to think about what the data are saying and what they represent. Also, when we're comparing populations, we have to be very clear that certain populations and zip codes have historical patterns that will influence this. Oftentimes, these algorithms represent police behavior as opposed to actual individual behavior. My colleague at NYU, Ravi Shroff, has a great graph of where people actually police and where the crimes actually happen, and they are not an overlay exactly of that. And my heart goes out at the end of the day to the government employees who are overworked, who have a system with an incredible throughput because of the level of arrests, who are trying to cope with it and trying to find technology solutions. But in that task, I think that there's a lot more power that government employees could have to think about where the algorithms are coming from. What's the provenance? Who owned it? Why was it created? Has it been used in my state? Are the base rates occurring in my state? Has it looked at the populations that are similar in my state? Those are really valid questions that someone could ask a vendor to make sure they're getting the right kind of thing that actually works. And then also, what's the training data? There are lots of studies that the training data for Compass were based on populations that are not the populations that they're used on. These are fairly straightforward questions that is striking to me that we're implementing these systems that are impacting millions of people, where we have not done this basic understanding of where they come from, what they do, and do they fit my environment. And if we take a step back and think about those issues, a lot of the conversations that we're all having and sharing today would be moot if they had just done this basic due diligence. So in conclusion, I just want to say that it is possible to argue with algorithms, and it's not rocket science, but it does take looking very carefully at what questions you're asking, what data are available, and then determine whether you're trying to solve the right problem.
Thank you. I think it's so fascinating to think about. We often talk about technology as a tool for transparency and the ways in which it actually ends up being used to obscure often, right? And what can we do to make it more transparent? I'm curious, as you were talking about, well, first let me say, I'm a fair housing lawyer, right? So hearing, where you live matters, and why disparate impact is so important, right? That we need tools to be able to challenge something that seems neutral in its face, but then when you look at who it's impacting, it's actually not neutral at all, right? It's really affecting a protected class. And in thinking about algorithms, I've been hearing a lot about algorithm trees, right? And how we have this very complicated system that's often very difficult to tease apart. And I'm curious about your thoughts on what do we do if there are so many inputs into an algorithm that teasing it apart becomes very difficult? And how do we hold these systems accountable to be able to tease them apart to understand what are the inputs that matter the most? And what do you do when it starts to become, you have a computer processing all of the trees, and so there's no, how do you tease apart what's leading to a sort of disproportionate impact or outcome?
Yeah, so as an organizational scholar and a computer scientist, I'm aware that there are human beings behind those trees and that somebody is making a decision to implement that. And so someone could also make a decision to not implement it in a way that's complicated, right? That's just a management decision. And I think there's a lot of management abdication of responsibility in these situations where they are they're letting the technologists do whatever they want, where these are strategic decisions. Like if I'm running an organization, it is strategic to me whether I'm going to glom on so many algorithms together and tape them together with gum and say that that's the answer, versus taking a step back and saying to your data scientist, well, how do you explain this? What are your inputs? What are the simple ways that you can explain this? And does that follow existing policy, right? Maybe somebody interpreted policy in a way that somebody who knows the law really well wouldn't know, or forgot about an outlier situation. And it's 80, as a computer scientist, my people, but we're going to be really good at 80%, and then like the next 20%, we're going to go to lunch, right? So I think that there's an opportunity that someone can push back and say, we're going to spend the next 2 years on that 20% and make sure that this is clear. And that's really a management choice, to not leave part of the population out hanging.
Thank you so much for inviting me to be a part of this really important conversation. And I wanted to start with a quote by Professor Robin Lenhart at Fordham Law School. She recently said, "When you're talking about power, you're always talking about race. When you're talking about power, you're always talking about race. And when you're talking about the law, you're talking about power. So you're talking about race. And when you're talking about technology, you're talking about power. So you're also talking about race. So when you're talking about law and technology, you're talking about a lot of power. And you're talking about a lot of race-based issues. And that's why this conversation is so critical. And so part of what motivates my research is how can law and technology be commandeered to serve power? And how can that power end up in some type of disparate impact or disproportionate impact on the basis of race? And so that leads me to research that focuses on data surveillance, cybersecurity, privacy, and the impact on race. And so 2 recent articles that I've been working on that I'd like to share with you today involve algorithmic-based voter purges. So when you're talking about voting, you're talking about power. And voter-based purges that then are based on law and technology that end up in influencing our elections is very much about power, race, and the law. Another article that I'm working on is about social media surveillance and the implementation of social media surveillance programs through administrative agencies under the Privacy Act. And so something else that I focus on in my research is looking at the irony of the law. So very much like the 14th Amendment under Plessy v. Ferguson, using an equal protection clause to perpetuate a doctrine under the law, separate but equal, very ironic. The use of laws such as voting rights laws to then implement technologies of discrimination, or things like the Privacy Act that is implemented in order to preserve and serve privacy interests in order to destroy privacy interests, is also very ironic. But how are we using technologies in order to implement that? So when I heard about the exact match law in Georgia, for example, in the most recent midterm elections, I wondered if they're using an algorithm to conduct a voter purge and it's leading to some type of disparate impact on the basis of race, what is that algorithm? So is it time to argue with that algorithm in the state of Georgia? So the first thing that I wanted to understand was what was the legal mechanism that allowed for them to conduct the voter purges in the state of Georgia under the exact match law, and then what was the technology that they were using to implement this? And was it an algorithm at all? Or was it not an algorithm, and maybe they should have been using a more accurate algorithm? And these were just questions that it left in my mind, and it led to the current article that I'm working on called Algorithmic-Based Voter Purges that will be forthcoming in the Harvard Civil Rights, Civil Liberties Law Review. So voter registration lists are the gateway to voting. You cannot vote unless you are on a voter registration list. How are states maintaining that voter registration list? What technologies are they using to say that they are maintaining the list accurately? And what types of technologies are they using to clean up their voter registration list? So under federal law, the National Voter Registration Act, and also under the Help America Vote Act, states are required to maintain the accuracy of their voter registration laws, and it was an outgrowth of the Voting Rights Act of 1965. So 50 years after the Voting Rights Act of 1965, there are now these technologies and these laws that are intended to preserve the right to vote. So NVRA and HAVA are both laws that were implemented by Congress in order to preserve the right to vote. But what are states doing to actually maintain voter registration lists? So in the litigation that is the outgrowth of the exact match law and the voter purges that we saw from the most recent midterm elections, first of all, I wanted to back up and state that you probably saw in the news about the disparate impact of this law. So the Georgia exact match law was passed in 2018. It required a precise match between the names listed on a government-issued ID with the names on the voter registration law. So it was implemented, passed, executed pursuant to these two federal laws that required the maintenance of these accurate voter registration rules. So part of the requirement of the exact match laws were that the records held by the Social Security Administration in the state of the Georgia's Department of Driver Services and other governmental records had to precisely match. The Associated Press then issued a report after they were examining the nature of these exact match protocols, and they found that although Georgia's population is approximately 32% black, they said that the voter registration lists on hold or were pending by the Georgia Secretary of State was nearly 70% black. And they said that Georgia had canceled over 1.4 million voter registrations since 2012, and nearly 670,000 were canceled in 2017. Then they also, in the lawsuit, stated that 53,000 voters' applications were considered pending and were not certified for clearance to vote in the 2018 election because of some type of issue with the exact match. In the litigation documents, you'll find in one of the responses by the Georgia Secretary of State to the attorneys that they state that there is what they call a HAVA algorithm. So HAVA, Help America Vote Act algorithm, appears to be being deployed by the state of Georgia, but we don't know what that algorithm looks like. We don't know, to my knowledge, unless the attorneys in that case have now unearthed it, exactly what data they used, what databases, how are they matching it, how are they coming up with these discrepancies, how are they then conducting some type of matching process in order to clean up their voter registration rules or make sure that their voter registration rules are accurate in such a way that's leading to this massive disparate impact. And if you look at the litigation and the types of legal theories that are being presented by the attorneys, they're under violations, or they're claiming violations of the National Voter Registration Act, the HAVA, Help America Vote Act, under constitutional claims. But are we missing the technological deficiencies in our examination of how these voter purges are conducted in such a way that we are actually going to miss the nature of the real issue here? So that's one article. The next article that I would like to share with you that I've been focused on is called The Ironic Privacy Act, and that's forthcoming in the Washington University Law Review. So what I wanted to examine here was focusing on one Federal Register notice that was published by the Department of Homeland Security on September 18th, 2017. It had a very innocuous name. It was Privacy Act of 1974, semicolon, System of Records. Sounds very, very innocuous, and under the Privacy Act, the federal agency was required to put the public on notice if they were going to update or modify their system of records. But what you will see in this Federal Register notice is that the Department of Homeland Security is announcing that they are modifying their system of records to include social media data. So it is a massive change to the way that the Department of Homeland Security will be conducting their data collection, storage, use, application, analysis process, including, most likely, the deployment of algorithms in order to, what they say in the Federal Register notice, to detect patterns of risk. And so what we see with social media is that it has created such inconceivably large volumes of data that is now publicly accessible to the government. So you have basically the government able to monitor the uploading of hundreds of millions of photos that might lead to facial recognition technology. Individuals send 500 million tweets a day, 300 hours of video on YouTube. Each minute is uploaded, the creation of 6 new Facebook profiles each second. This is a huge amount of data that is being made available to the government. The government is very interested in monitoring this data. And how are they going to get access to it legally? How are they going to explain how they're going to use this under the law? That's something that is very interesting to me in my research. So what I'm particularly interested in is the relationship between this Federal Register notice that was released on September 18th, 2017, and what was referred to as extreme vetting as a part of the Muslim ban. So the former candidate Trump, when he was running for office, announced on December 7th, 2015, that there would be a Muslim ban. He said on a statement on preventing Muslim immigration on his campaign website, he stated that he was, quote, calling for a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. Then shortly before his election, he announced that he was going to roll out a program, what he called extreme vetting of immigrants and refugees. He explained, quote, the Muslim ban is something that in some form has morphed into an extreme vetting from certain areas in the world. So what does extreme vetting mean? So then Department of Homeland Security Secretary John Kelly, when he was testifying before Congress, explained that it would be, quote, accounting of what websites they visit. It might be telephone contact information so we can see who they're talking to. And then he said social media and passwords. So then later on, the Department of Homeland Security, you might have seen this in media reports, held an industry day, and they circulated a document entitled Extreme Vetting Initiative to leading technology firms who attended this event. And they explained that they were looking for some type of vetting tool that automates, centralizes, and streamlines the current manual vetting process. And they said that they wanted to determine and evaluate an applicant's probability of becoming a positively contributing member to society as well as their ability to contribute to national interests and determine, quote, whether an applicant intends to commit criminal or terrorist acts after entering the United States. So basically, they were looking for whether or not there could be an algorithm to detect criminalistic or terroristic behavior. In this document that they circulated, they stated that they wanted the contractor to analyze and apply techniques to exploit publicly available information such as media, blogs, public hearings, conferences, academic websites, social media websites such as Twitter, Facebook, and LinkedIn, radio, television, press, geospatial sources, internet sites, and specialized publications with intent to extract pertinent information regarding targets, including criminals, fugitives, non-immigrant violators, and targeted national security threats and their location. Basically, all publicly available information that might be at the disposal of the contractor. They stated that what they felt was one of their concerns, one of their biggest constraints, is that they were limited to what was publicly available. What we see through something like this Federal Register notice, especially once passwords might be accessed, is that it's no longer publicly available information only. That would be at the access of the government, but you might also have then, under whatever privacy settings, other social media data, but not only the social media data of the person who is entering into some type of process with the Department of Homeland Security, but also all of their social media associates. And in this notice by the Department of Homeland Security, they state that the social media files will be held on both non-citizens, but also naturalized US citizens. So in the comments, and the comments that were registered in response to this Federal Register notice was in the thousands. So thousands of people responded to this Federal Register notice. On the date that it went into effect, I believe it was approximately 2,000. I believe if you go to the website now, that there's over 4,000 comments that were sent to the Department of Homeland Security. Many of them very concerned, for example, that this would create a second-tiered citizenship category for those who were naturalized US citizens. And what kind of records would be kept on those who started off as an immigrant, but then became a US citizen through naturalization, but now what types of records were going to be kept on them in their A file or their alien file. And also, the A files are kept on storage for 100 years or more. So potentially this social media data collection would be kept on these individuals for, who knows, 100 years, maybe longer. And that's one of the risks that we take with digital files, digital records, that we don't know how long it's going to be used for. And many of the comments express concern that given that this is a form of now data collection, storage, and use that potentially implicates very fundamental core constitutional rights, First Amendment, Fourth Amendment, 14th Amendment rights, that you might have equal protection at play. You might have citizenship rights at play. Is it appropriate to announce this type of program under a Federal Register notice, under the Privacy Act, or really is this something that Congress needs to approve? So in conclusion, just wanted to end with the words of Professor Robin Lenhart. When we're talking about power, we're also talking about race. We're always talking about race. And thank you so much for the ability to engage in such an important conversation.
So thank you, Professor Hu. I have a follow-up question and then some questions that we can maybe all talk about. But when you were listing the factors that that DHS is looking at, right? You talk about, is somebody likely to engage in terrorist acts, but then also questions of, how are they going to contribute to our national interests, and are they going to be productive members of society? And what the alarm bells it sets off for me, right? Of course, subjective factors, right? And we know so well that subjective decision making leads to discrimination. It leads to problems around how we address race in this country. And is anybody looking at those factors as they go in? Are they objective? or are they subjective? And is there just an assumption that because they're algorithms or technology that it's an objective measure? Is that anything that's being talked about?
Well, I think that that's one of the huge risks of these types of black box decision-making systems, and also the automation of the systems. Are we actually going to have the opportunity to examine how the algorithm is going to be read? Are we going to have the opportunity to interrogate how the algorithm is built? If we have neither, will we be able to have any point of intervention that's meaningful legally in order to question the subjectivity of the ultimate resolution that is dependent on those technologies?
So we have about 15 minutes. Let me throw out a couple. Well, I'll throw out one question first, and then we can open it up, and I have a couple others if we don't have questions. So we've talked a lot about all of the risks that come attendant with the use of algorithms and technology. I'm curious as to whether you all see any positives, right? What are the things that we can do to help address these problems using technology, using algorithms? Is there opportunity for that, or are we really in a space where we need to think most critically and most frequently about controlling?
So what's interesting in the context of actuarial risk assessment tools is that they were actually created by rehabilitation scholars. So very brief, history of sentencing is in the 1970s, right before we started increasing our reliance on incarceration, we also turned away from a focus on rehabilitating criminal offenders through sort of the punishment system, right? So we sort of scrubbed it out of our sort of sentencing frameworks, and we started defunding rehabilitation programming in prisons. And a number of rehabilitation scholars, and that was it was problematic, but there were some well-intentioned reasons for it. The concern was that it was, rehabilitation was too subjective, and it was, leading to racially disparate sentences and things of that nature. And so as the sort of trend moved away from focusing on rehabilitation, the individuals who still believed in rehabilitation sort of turned to empirics and said, let's collect some data and demonstrate that rehabilitation is possible. People really do rehabilitate with sort of positive interventions, employment training, education, access to education while in prison, and things of that nature. And what they produced was a risk assessment tool. And that tool was implemented, or was originally envisioned as a way to identify how best to intervene to improve the likelihood that people would not engage in criminal behavior before, or again, I should say, and to inform what kind of treatments, what kind of services would be most effective for an individual. So part of the problem here is that, it is well-intentioned. I mean, these are like some of the sort of most well-intentioned individuals you can imagine who are sort of creating the foundation for this expansion of generalized technologies that simply categorize individuals. The challenge is that we don't think about sort of exactly how we're using it. It's not like, we only use risk assessment tools to identify individuals for treatment. No, we use risk assessment tools to identify people for an increase in incarceration. We use risk assessment tools to simply categorize individuals so that we don't have to critically think about sort of the hard questions about engaging with individuals. And so there's always a potential, I think, in a lot of these technologies. They're often very well-meaning or well-intentioned in the way they're used, but I think that there is a sort of a comfort or a desire to have sort of panacea solutions, right? To say, like, this is the way that we can fix things, so let's use this in every way possible. I mean, some of the predictive tools that are used in policing now are supposed to be, it's like they have this tool that is supposed to predict people who are likely to be victims of like gang violence. And I mean, that's a great idea, but if you actually know how police work, then you would know that identifying all these individuals is going to lead to more surveillance, and more surveillance is going to lead people into the criminal justice system for a number of factors, again, that appear to be objective, but are being used and are being conceptualized in ways that are not objective. And so, it's not about saying like, oh, we don't want any technology anywhere, it's all bad. But it's also being able to say, there are things that, and Dr. Washington, sort of alluded to this at the end of her talk, and I thought it was great, just saying that in some ways we're allowing technology to run amok. We say like, oh, we figured out something and let's just use it, instead of saying, here's what we need, and here's what we can, here's what we've got, and here's what it can do to get us towards that, right? So some of it is saying like, we have to take the reins and say, this is what we want our criminal justice system to look like. This is what we want our, our voting participation to look like. And then to say, here's how technology can help us get there, instead of saying, technology has given us this, and let's use it.
I just wanted to concur with a lot of what you're saying. The questions that I talked about from the data, this is why they exist. This is why they're questions about community and family, because originally this was a needs assessment tool that was designed to help people get services, and it got translated and conflated with a risk assessment score. I think technology can do an awful lot. You have 2 million words. Why read every single letter? That's what a computer can do. I mean, it's a classic issue. There's something called the FITS list, F-I-T-T-S, and that has a great distinction about what humans are good at and what technology is good at. And I think what the problem that we're having is that we're conflating the marketing tools, how people market technology, with how it could actually help people in the public sector. And if we took the marketing away and said we can solve this narrow problem in this particular circumstance using computers, then I think we'd have a better success rate than, and we wouldn't have to do so much criticism.
I think that one of the greatest risks is that the seductiveness is that the use of the technology will always lead to more objectivity, neutrality, transparency, and efficiency. And it isn't always that case, especially if it's being used for improper purposes.
As you were talking, I was wondering, what are the ways in which we could use technology and algorithms to actually increase voter registration, right? What are the things that we can do to really live up to the ideals of HAVA and NVRA and get more people on the rolls, and it's not what we're using it for at all, right? But we could do that, certainly.
And part of that is about empowering communities to say, this is what we want. We want more people to be able to vote. We want, more democratic engagement. And, that's not who the technologists are really serving, right? These are often privatized, services that are being purchased, potentially by the government, but also just being rolled out, for their own purposes. And unless we are able to say, like, this is what we want the world to look like, we're going to see sort of a replication of problematic features.
So are there any questions from the audience?
Hi, Joe Miller from Washington Tech. How are you today? Interesting question that you raised with Plessy v. Ferguson and talking about the historical bases for a lot of these things that are still perpetuating. I'm just concerned about the extent to which you're thinking about how this is volitional, right? Because when we had 13th Amendment from the documentary on Netflix, of course, you can see that the prison system was used as a proxy for discrimination. When you had desegregation of public facilities, you have things like pool membership prices being astronomically high to keep people out. When you have any other type of discrimination, there seem to be historical proxies that are created to perpetuate the existing disparities. And I'm just interested in your opinion on the extent to which these things are, to some extent, intentional by some, that some are using them in an intentional way.
Before the lawyers speak, I'll just jump in. I I teach the class on ethical data science at NYU, and through this semester, I've been very aware of how technology is willing to cut corners to get something up fast. And if there's volition in that, there's a tendency to leave out certain groups in that process. And that if we don't have an intentional process to come back and do something for everyone, then we ended up with lopsided systems.
I think your question is so important because a lot of anti-discrimination law is dependent on proof that there is discrimination. So is there discriminatory animus is often the foundational question before you can even get to then some type of remedy. And if it is a technological methodology that's being used to execute something that leads to some type of disparate impact, is it going to be covered under the law? And I think that that's an argument that's being made right now, that disparate impact doesn't necessarily correlate to volition or intent, that there was no intent to discriminate. And so why should the government be held to some type of anti-discrimination law standard when there was no intent, or 14th Amendment standard when there was no intent to discriminate? And I think it's going to be very problematic.
There was another question.
Having here trouble, so hopefully you can hear me. Kafi Kumasi, I'm professor at Detroit, Wayne State University. I was wondering if you could talk to any correlation you see between, like the SAT board now has this adversity risk assessment where they're trying to come up with a new measure to account for diversity or adversity. And that's proprietary. It's coming from the SAT board. We know they have an investment in continuing their continuing the reliance on or over-reliance on standardized tests. These other measures seem to be coming from other entities. So I'm not sure if, for example, the prison risk assessment, is this being funded by the prison board? Or so are you seeing that correlation with private industry that's coming up with these risk assessments to basically keep themselves in business, and just kind of comment on that?
Yeah, so I think we both could answer this. There are a number of risk assessment tools in the criminal justice context. Some are developed by states, some are developed by private entities, some are created by public-private entities, like universities that have some private funding, and so you get a mix. It's my opinion. I mean, I think that there's some critical distinctions that happen between the public and the private tools. I mean, you don't have access to the algorithms, and that is critical. But there's also critical similarities. I mean, oftentimes the publicly created risk assessment tools are seeking to be just as technically accurate as the privately developed risk assessment tools, and so I think that's part of the concern, is sort of what are the incentives to developing these tools. But as Dr. Washington alluded to as well, I mean, part of those incentives are to get a tool up and running very quickly. What kind of access, what data do we have access to? And those questions, are very similar for a public institution just as much as a private entity.
Yeah, and I want to emphasize the iterative nature of these things. So anyone who just releases a new algorithmic tool, that it's still very beta, and there will probably be a lot of iterations that, and I think this is a real question. We talk about algorithms as if they are one thing and static in time, and as data changes, the algorithms will change and the calculations will change, but our values will not. And what it is that we're trying to accomplish will not, which is why it's so important for people to be able to articulate what the value system is around the algorithm that they're constantly trying to solve for.
Unfortunately, I actually disagree with that. I mean, in theory, our values don't change, but it's my perception that as the technology advances, our values are shifting to try to accommodate technologies as much as we are sort of trying to do other things. So the value of technical accuracy. Yes, we care about technical accuracy, but we have other values as well, right? Like equality and, whatever else, that comes to mind. But as we have, as Professor Hu sort of alluded to, we have the seductiveness of technology that just sort of draws us along with it if we don't sort of take the reins ourselves. And I think that is also a big threat with the introduction of these kinds of technical solutions in so many different contexts.
Yes, I agree. I take your point. I'm thinking that if I see algorithms as recipes, right, and I might have a recipe where I value 900 calories in this meal, right? I know what it is that I'm going for. I could have a vegan algorithm. I could have a big juicy burger algorithm, right? So if I know what it is that I'm solving for, then there's a lot of variation in there. And I feel that right now we're acting like there's just one meal, it's Soylent Green, and we're just all gonna eat it. And that's the problem. We just need to know what it is that we're trying to accomplish.
Yeah, I think that actually goes to what both of you are saying, right? Which is that if we can have the conversation around what the goal is, rather than what are the technologies that we can use and what are the various goals that can come from those technologies, that we can be a little bit more intentional about how we use the technology.
This is for the lawyers. So I particularly want to talk about the confluence of Fourth Amendment trade secret law and kind of like Ninth Amendment ability to police when talking about kind of these algorithms, like the state having sovereign immunity and its policing power to be able to keep or kind of like maintain its policing practices, right? And whether those three things have confluence when talking about algorithmic bias and in algorithmic bias as it relates to criminal justice. And then second part of the question is on a kind of what to do about this issue. Couldn't we also mandate that counties and states input certain language inside of these contracts that they engage in with these private entities to make the data publicly available and to make the data kind of subject to civil rights kind of I would say analysis or background?
I think that's such a fascinating question. What is the role between the federal government and the state and with civil rights laws? You've seen, and I worked in the Civil Rights Division for almost a decade. So I was part of the effort to implement the civil rights legal apparatus intended to redress the racial wrongs. And so the federal government has stepped in over and over again to try to police discrimination that's occurring in the states. But what we see in privacy law, it's very fascinating that it's really the states that are leading the charge. And our founders intended that separation of powers. They didn't want centralized power. And the states are the ones often pushing back against what they see as the federal government's overreach and wanting to collect all of the states' data, for example, and playing a very important role in protecting the data of the citizenry at a state level by refusing to just hand over the data to the federal government or being an arm or surveillance arm of the federal government. And so I think that it's a really complicated question that you're posing. And I think that as our lives and as technologies become more complicated, we need more separation of power. We need more decentralization of power. Going to the second part of your question about whether or not for state and local law enforcement who are now contracting for these types of risk assessment tools and algorithms, whether or not they can embed within the contract some type of transparency, it goes to the other question about the proprietary nature of these algorithms. And so there's a lot of intellectual property rights that are being attached to the development of these systems, and the companies do not want to give that up. So I would even imagine that they'd be willing to walk away from the contract rather than make their tools more transparent.
So I think we're out of time, but if there's one more question, I think we probably can take one more question. Done? Well, that was perfect then. Thank you all so much, and thank you, everybody.